welcome to Zulu Alpha Firearms channel. I'm Gerald Labuschagne. As you know, one of our missions on Zulu Alpha is to actually try and help people remain legally compliant in this very complex world of firearms ownership in South Africa. So there are a few questions that seem to pop up fairly regularly if I look at different websites, Facebook pages, etc., and just some questions I had myself that often we get conflicting answers to. People who comment on Facebook pages aren't necessarily legal experts. Often people give their opinions, which is not necessarily a legal opinion too. So I thought to try and help us sort of navigate this whole field, we will come to Martin Hood and Associates. And amongst other things, one of the areas that they focus on is really firearms issues and the law. So that's where we are today, and we'll hopefully get you some decent answers. So Martin,
Hi, Gerald.
thanks very much for being on the show. Before we get into the actual questions, do you want to tell us a little bit about what do you guys focus on in terms of firearms and the law in your practice?
Well, many years ago, 25 years ago, I was a beginner sport shooter, occasional clay target shooter, and I started getting asked more and more questions on the shooting range about how do I do this, how do I do that. I was asked because I was an attorney and because I knew a little bit about the law. And over time, as you can see, I developed a bigger and bigger interest in firearms from a personal point of view. I'm a collector, a sport shooter, hunter, and I found myself in the fortunate position where I gravitated towards doing the type of legal work that also reflected my passions. So most of my work, most of the practice work is firearm based, from applications, appeals, declarations of unfitness, court review applications, through to assisting the security industry. It's quite a complicated regulatory environment in the security industry. And a number of the associations, professional hunters, hunting associations, and so on, Professional Firearm Trainers Council. I help write training manuals, I give advice on the content of the legal sections, and anything basically that you could imagine to do with firearms, including, for example, the more unfortunate type of work that would include criminal work where firearms are used in self-defense.
Okay, so it's the whole spectrum from
Everything.
literally application process to people who got in trouble in terms of their firearms.
Absolutely.
Okay, and do you find businesses getting more increasing in terms of firearms law issues?
What I find, unfortunately, is that we have a complicated regulatory environment. And the environment is not helped by the failure of the police to give us guidelines, to give us information, to communicate with us. And that creates uncertainty. And in that uncertainty, people often find that they cannot comply with the law, or that they misunderstand the law, or that the police misapply the law. So, short answer is the regulatory environment, because of its complexity and because of the lack of guidance from the police, is very, very busy.
Okay, all right. So good for you, but unfortunate for the rest of us firearms people that is actually the context and the background to why you're so busy.
I've always maintained that in a normal world, you shouldn't need to come to a lawyer to get a firearm license. Unfortunately, because of a multitude of reasons in the firearm environment and the politics that go with it, it's becoming more difficult to get firearm licenses.
All right, so let's perhaps jump into some of these questions, and we can help people avoid ever having to perhaps come to you for some of these issues. So the first kind of two questions relate around sports shooters. Now, you said you're a sports shooter, I'm a sports shooter, and I know this issue has come up a lot on the shooting range, and as I said, on a lot of the groups that I kind of follow. So the first one, which kind of leads into the second one, is if I have a Section 16, let's say a Section 16 pistol. In other words, a pistol is issued for me as a dedicated sports shooter.
I'm anticipating the question.
Can I use that
Short
for
answer.
non-Section 16 purposes?
Short answer is yes. And I practice what I preach. So for those of you who are watching, I often carry a Section 16 firearm when I go about my daily business. The reason for that is quite simply that the Act allows you to use a firearm where it's safe and lawful to do so for any purpose. Now, that is interpreted generally that you can use your Section 13 firearm license for occasional sport shooting, or you could use your Section 13 firearm license for dedicated sport shooting. There's nothing stopping the reverse applying. And I think what we also need to bear in mind is the purpose of the Act. When it was initially drafted, and I can speak from personal experience being involved, the purpose of the Act was to limit the number of firearms in circulation. And it was expressly provided for at that time that a firearm could be used for more than one purpose. Hence those provisions in the Act that you can use it where it's safe and lawful to do so and for a lawful purpose.
Okay. So, I mean, because I think, like you said, most people don't really have a difficulty to think about me using your self-defense Section 13 gun for sports purposes. In fact, before you can actually apply to become a dedicated sports shooter, you have to get your 6 points. So what firearm could you use? And of course, logically, you would argue that I could use my self-defense one.
Well, ironically, there are some sports shooters and some hunters who don't own a Section 13 firearm, but they have a handgun, for example, which is the most commonly used firearm for self-defense. And it would be ludicrous to suggest that they can't use a licensed firearm, licensed for one purpose, for another purpose to protect themselves. I don't think that any court would hold that against them. And that's why I'm quite happy to say, very simply, yes, you can. There's no doubt in my mind that you can. And as I said, I practice what I preach and I do it myself.
I mean, I just quickly went through the Act, and that would kind of, if anybody wants to refer to that, if you look at Section 16, subsection 3, a firearm in respect of which a license has been issued in terms of this section may be used where it is safe to use the firearm and for a lawful purposes. It doesn't say only sporting. So that's if people want to go look at the Act, that's where you go to.
And you can take it one step further. If the government didn't intend that, then they would place some form of limitation on these sections because it applies to Section 13, 15, 16, and not Section 20, which is business firearms, and I think it applies to Section 17 as well. If government didn't want that, then they could take that provision out. Yeah. It's as simple as that, and it's been there for 15 years.
So it may only be used for sporting, for example. So this kind of leads me to my next question, and this kind of popped up. I did recently a video for an overseas YouTube firearms channel called TFB TV around firearms ownership in South Africa. It was really just intended to give the Americans an idea of how things work here. And one of the things I commented on is the possession of ammunition and how on a Section 13, you're supposed to only be able to be in possession of 200 rounds for the self-defense license. And in Section 16, which is a sports license, you could have unlimited in the caliber of firearm that you have. And now some people came back to me and said, I'm wrong with that. And at first, they kind of said, no, it's your dedicated status, which actually gives you permission to have unlimited. And I thought, that's a lot of nonsense, until I kind of went and looked at the Act, and I thought they might actually have a bit of an argument. I can't say whether they were right. And the two scenarios I want to sketch before I give you a chance to answer that is...
I'm chomping at the bit.
Yeah, you can see it. So scenario 1. Some people say that although the Act says a person who has a Section 13 self-defense license, if they have become a dedicated sports shooter using that Section 13 firearm for sports, and they don't have another firearm, their dedicated sports status that they get, that letter that they get from whether it's SAPSA or a different body, would allow them then to purchase more than 200 rounds of ammunition and be in possession of more than 200 rounds. And I think for me, kind of makes sense. So let's say I have a Glock 19, which as we all know is the best pistol in the world, and I want to use this now. It's issued to me on Section 13, but I want to use it for my sports, and I get my dedicated sports status with my Section 13 Glock 19. Surely I should then be allowed to buy more rounds because I maybe don't want to buy a different gun. I don't want to buy a Shadow 2. I don't want to buy a second firearm. I don't have the money or whatever reasons. Shouldn't I then be allowed? And I think there's a logical argument. I'm a dedicated sports shooter. My firearm is Section 13. Why can't I now be able to buy more firearms?
There's a simple answer, and that's buy another firearm.
The second sort of scenario, which someone posted me, which I wasn't so sure if I agree with them, is let's say I have a 9mm Section 13 self-defense. I have a .40 on a Section 16 license. So 2 firearms. One is sporting, one is not, different calibers. Would my sports shooter status allow me to be in possession of more than 200 rounds for the 9mm, for which is issued on Section 13? In other words, the argument there is, irrespective of how many which calibers I have on Section 16, the fact that I'm a dedicated sports shooter in one of those calibers means I should be able to buy as many rounds in any of those calibers. And I'm not so sure about that argument.
I own 2 Glocks first of all, so for all those Glock people out there, I'm one of the club. Also a perennial question, how much ammunition to Section 16 and so on. And before we specifically address the question, I think we need to bear in mind 2 things. The first is that dedicated status is not something that the police give you. An association gives it to you. So it falls outside of the police's records. They only have a record of it when you get a dedicated Section 16 license. And the second thing is that when you go to a firearm dealer, he's going to sell you ammunition based on your license. He's going to say, show me a license. And you will have an argument with some dealers if you produce a Section 15 license and want to buy 1,000 rounds. Now, the reasons for that must also be contextualized in terms of what the aims and objectives of. The reasons for that must be contextualized in terms of the aims and objectives of the Firearms Control Act. We mustn't forget that it's about controlling arms and ammunition. So then we have to ask ourselves the question, would the police intend that you have an unlimited amount of ammunition, or would they want to control the amount of ammunition that you have access to? And my view is that because of what the Act, what it intends to do, it intends to control arms and ammunition, we must take a conservative look at it. We must take a conservative perspective, and I don't think that the intention of the Act was ever to allow a person, simply by becoming dedicated through an association, to purchase unlimited amounts of ammunition. I do not think that was the purpose of the Act. I accept that the wording of the particular section is ambiguous and that it is subject to interpretation. However, I want to fall back on what I said, and that is the police don't know you're dedicated until they issue you a license. A dealer won't sell you ammunition until you produce a license. If you take those factors together, my view conservatively is that the amount of ammunition you can purchase is linked to a specific license, not a status. And I say that simply because I think that the police would not have intended the wording of the Act to be as it is and to allow people an unlimited amount of ammunition, because the purpose is to control arms and ammunition. And we mustn't forget that purpose.
Because I think, and I agree with you, the Act is sort of, it's ambiguous. I mean, if you look at Section 91 for our viewers, if you want to kind of follow this up, it says Section 91 is restrictions on possession of ammunition. And it says, point 1, the holder of a license to possess a firearm referred to in Chapter 6 may not possess more than 200 cartridges for each firearm in which respect he holds a license, or she. Point 2, limitation in subsection 1 that we just mentioned does not apply to a dedicated hunter, dedicated sportsperson, or a professional hunter who holds a license issued in terms of this Act. So the confusion there, it speaks about the dedicated sports person.
Well, again, from an interpretation point of view, the first question that you ask when you're interpreting legislation is, what is the intention of the legislator? Now, they make reference there to holding a license. It's unfortunate in the way that they structured the two subsections, because they do not link directly to each other. But I am relatively sure that had that to be interpreted by a court, the more conservative interpretation that I've put forward, which is it's linked to a license, because they make reference to a license as well as the person. But the difficulty with the person is dedicated status is not something that SAPS knows about. It can be given to you without owning a firearm. And no one would suggest that you could go to a gun shop and say, I've got a dedicated status, therefore I want you to sell me ammunition. It has to be linked to a license. That's the first part. The second part is that that license is broken down into different sections. Section 13 says only 200 rounds. And there is a means to get an exemption, which I'll mention just now. Section 15 says 200 rounds. Section 16 says unlimited. So what was the purpose of the legislator? The purpose of the legislator was, once you move into that more dedicated, precise category, you're going to need more ammunition, therefore you can have it. It's not, I would suggest that once you've completed a dedicated course and don't have a license, you're allowed an unlimited amount of ammunition. So I think the purpose is fairly clear, but I want to stress I do accept that it's subject to more than one interpretation. I think my view is also supported by the fact that the Act makes provision for an exemption. So you can apply for an ammunition exemption if you are not dedicated and you want more ammunition or you need more ammunition. So again, looking at the construction of the Act, the overall construction of the Act, it doesn't provide an unbending limitation on the amount of ammunition. If you are a sports shooter and you only have a Section 13 or 15 license, you can apply to be exempted from that ammunition limit. And I think that also speaks to you've got to have a Section 16 license. And then finally, I think you must bear in mind as well that it talks about license and dedicated person, but the license is what is necessary to purchase ammunition. So to argue that I've got a 40 caliber and a 9mm, one is a Section 16 and the other is self-defense, that I'm allowed an unlimited amount of ammunition in the non-dedicated caliber, I think that's a little bit false. So bottom line, put forward simply Section 16 firearm, no limits for that license and that caliber or any other caliber that firearm can discharge. Simple.
And we don't, you mentioned, court cases, which are often how we get some kind of, if it's in the High Court, some precedents that we can refer to. But even I think judgments in the Magistrate Court can plus be used in arguments. But we haven't had cases where this was discussed, as far as you know, in a courtroom?
No, and as much as I'm a lawyer, I always caution people about trying to go and get a court to interpret legislation because it can work both ways. It may be that an issue, and unfortunately we've had a number of instances where, for example, the interpretation of Sections 24 and 28 of the Firearms Control Act, the renewal provisions, they were challenged and unsuccessfully so in the Constitutional Court, and it closed a door to all of us where we might be in a different situation had that challenge not been mounted. So one must be very careful about saying, let's go and get an interpretation of it because it could actually work against us firearm owners. So the uncertainty actually works to our benefit. Let's keep it like that. If you have a problem, go and get a dedicated license.
Perhaps a more interesting way and safer way for us to do it would be to find a Section 13 license holder who's got their dedicated sports status and then applies for the exemption to get more ammunition using that argument and actually see what the police come back with. And
they will grant it. They will grant it. It's as simple as that. You've got to provide a short motivation and explain how much ammunition you want. If you provide them proof that you're a member of a sports shooting association and that you participate in such activities, they will approve it.
So do you know people who've gone that route?
We've done it.
Okay, so that is, and not a lengthy, difficult process.
No, it's not. It's submission of a form with a short motivation. And even security companies that do, because a business license has the same limitation, even a security company can get an exemption because they might do more training than what the regulations require. And in order to do that type of training, they would need an exemption from the ammunition limits, and they get it regularly.
Okay. All right, so ultimately, again, you're responsible for whatever you do as an individual. You've heard one legal opinion. If gun shops want to sell you based on one of these arguments, that's in your hands and their hands to take whatever consequences might or might not come their way.
Well, I think you can choose to edit this out or not. To some extent, the limitation is a little bit artificial because you must bear in mind that at this stage of the implementation of the Act, we don't have electronic connectivity. So the police do not know how much ammunition you purchase. So you can go to one gun shop on a Monday and 4 other gun shops through to Friday and purchase your 200 rounds of ammunition, and no one would know anything for the better or for the worse. So again, I think sometimes perhaps we scratch where there's an itch that perhaps we scratch where there's no itch. It's not a big issue. You can always find a workaround in terms of the Act quite legally. If worse comes to worse, go buy a dedicated firearm.
So there are options. If you want to take a shortcut, there can be consequences that can backfire quite horribly. It's kind of what I'm also hearing from people, what the options are.
Well, again, the Act says no person may possess more than 200 rounds. Possession is not defined. So there's a great amount of latitude in the legislation for the interpretation to be disputed. I think as responsible firearm owners, we should all take the view that we will comply with the law insofar as the law is not ridiculous or incomprehensible. And in as much as we might want more ammunition, there's a way to get more ammunition. You can use the exemption, or you can get another firearm license in a dedicated category. Simple.
Hang on a minute. This is all very academic. What's the point of this whole discussion if we don't even know whether or not a firearm store will sell us more than 200 rounds of ammunition under these circumstances? So, in true Zulu Alpha fashion, we did a snap survey. We asked 20 gun shops in South Africa whether or not that they would sell us more than 200 rounds of ammunition on a Section 13 license with a dedicated sports shooter letter. And 9 of them were from Joburg, 10 from Pretoria, and 1 from Cape Town, just so the Cape Townians don't feel left out. And 12 of them said they would not sell us more than 200 rounds of ammunition under those circumstances, and 8 said that they would. So there you have it, almost 50-50 that you can purchase rounds under those conditions, depending on which store you go to. Now in the end, whatever decision you make is on your own head. If it backfires, that's your own problem. This is not my legal advice. Good luck. My next question, which is a bit different to the first ones, but I think it's, as I said, it's one that I've wondered about. I've heard people question often. How long is a competency certificate valid for? I've heard people say it extends as long as you have a license in that category. Let's say it's a pistol handgun competency. As long as you have a valid license for a handgun, it pulls the length of that validity. And if you renew it in time, it continues to stretch out that competency certificate validity. And other people say it's 5 years, 10 years. Do you have any opinion and clarity on that?
I can give comment, but I don't think that there's any definitive clarity on it, because the amendment to Section 10A created more confusion than clarity. So let's just go back a step. What many people don't understand is that competency is not a globular competency. It's broken down into the 4 categories: handgun, shotgun, rifle, pistol caliber, self-loading rifle, carbine, whatever they choose to call it. So in essence, you have 4 competencies, and it's each of those different categories. What then may happen is that you could have a license that expires on a certain date in one category, and other licenses in other categories with other expiry dates. And the typical situation would be your self-defense handgun, because that's only valid for 5 years. So if you have one handgun, in respect of a handgun competency, it's valid for 5 years, because the Act says your competency certificate is valid for your longest, for the same period as your longest license in that category. So with one firearm, it's quite simple. It becomes complicated if you don't own a firearm in that category, and a typical example would be a security officer. He has to have a competency certificate, but he may not own a personal firearm. How long is his competency certificate valid? The police have issued a directive saying that it is valid for 10 years. So that's one interpretation. Then if that person goes and gets a firearm license for a handgun, it becomes a different time period, because it's limited to the validity of that handgun license. And it becomes quite difficult to calculate. And again, if you have a very active shooter or hunter or collector that purchases firearms on a regular basis, you can effectively roll your competency validity for an indefinite period. And I don't think that was the intention of the Act either, because competency is not an indefinite thing. Competency is a here and now concept. You're competent or you're not competent, and circumstances can change. So again, my interpretation of the Act was the police intended to make a competency certificate valid for a period of time, whether it's 5 years or 10 years. But they didn't succeed in the wording of the amendment in achieving that. They actually achieved confusion. I believe that there will be amendments to peg competency certificates to a time period unrelated to a license. And that makes a lot more sense, because you can see the beginning and the end date of your competency.
And then you'd have to do a renewal.
You would have to apply to renew it. That makes much more sense, and it will do away with this confusion, because there is no simple, definitive or effective answer to say your competency certificate is valid for that amount of time. They don't have expiry dates on them, and it depends upon your personal firearm licensing circumstances.
Okay. Because as you said, my most recent one does not have an expiry date. So that I think creates confusion. And I think if you read also, I think, is it section 10, subparagraph 2, it says remains valid for the same period of validity as the period determined in this act in respect of the license to which the competency certificate relates. So on the one hand, like you say, that could be, well, the license is valid for 5 years, therefore at 5, you have to renew the competency. Or if you keep your license active, which if you're responsible firearms owner, you should be doing anyway, it just carries on forever.
And what they don't do is, when they issue a competency certificate, they talk about linking it to a license, but their records don't link it to a license. And on your license, there's no linkage either. And that, I think, is what creates much of the confusion. And the simple advice that I give people is check every 5 years, because that is the shortest time period for which your competency certificate could be valid. If the police say you need to renew your competency certificate, it's a simple process. Just do it. Don't argue or fight the system, because until we get a proper amendment clarifying it, no one is going to know. And the last thing that you want is to end up with an expired competency certificate when you could quite easily have avoided it.
And if it does expire, let's just say the hypothetical scenario is it has expired. Am I still allowed to carry my firearm with me? What's my status in terms of the license?
That's another interesting scenario, because it's not an offence to have an expired competency certificate. But of course, if your competency is linked to a license, then for your competency to expire, you must have an expired license, which is an offence. Okay, so you can see that it already becomes quite problematic, because no one will be able to determine whether you have an expired competence or not without reference to a firearm license. You may get stopped by a policeman and have a firearm license that has an expiry date on at a particular point in time, but you may have newer firearm licenses which would give you an expiry date of your competency further into the future. And it's impossible to tell that in the middle of the night when a policeman asks you, because all he's going to see is that firearm license. So we need to get a proper amendment that says your competency certificate runs from a period of issue for a period of time until it expires. And we're led to understand it's going to be 5 or 10 years.
Now, my next question, which I think would be an easy one to answer, but you never know with our Firearms Control Act. Do I need to carry my competency with me when I'm carrying my firearm?
No.
Okay, that was far shorter than I thought it was going to be. No.
But you must carry your license.
Absolutely.
Yeah, if I can just add. Gerard, you can see from the not so simple answers that as I preface my comments, it's a difficult regulatory regime. And it's not made any easier by bad wording of the legislation, bad training of police, and bad information that the police either have or they give out. And I think that it's very important for any responsible firearm owner, if they have a question about the law, to either approach their accredited association, because many of these associations have lawyers on call, or they have policies, or they have information documents that are properly set out, giving the correct answers. And I think it's important to stress correct answers, because social media is very problematic. There's a lot of bad information out there. If an association gives you an answer, the probability is that it's going to be a good or a correct answer. And then there's a number of attorneys who specialize in assisting people with the Firearms Control Act. A telephone call doesn't take much time, doesn't cost anything. Rather ask somebody who knows what the law is, as opposed to going onto social media and asking a group of people a question and getting 10 different answers. That's not helpful. It creates confusion, and ultimately that confusion is going to work against us, because the government is becoming less and less comfortable with us. The government is seeing us as a group of non-compliant firearm owners because of not renewing firearm licenses, because of what they perceive to be exploitation of loopholes. I'm not saying that that is correct. I'm talking about perceptions. So it's important that every responsible firearm owner or would-be firearm owner actually takes the time to find out what the law says before they do it. Otherwise, you become part of that non-compliant category of people, or you become part of that category of people that the government perceives to be looking at exploiting legislation, and ultimately that's going to be used as an argument to limit our rights.
Martin, thank you very much for your input. Thanks everybody. Again, hopefully you're in a better position now to kind of decide what you want to do. Ultimately, you're responsible for your decisions. If you don't know, as Martin said, get advice from people who are in the know. And make your choice. And I always say, make the choice that's going to err on the side of caution. That's what's going to be the safest. So I'm Jared Lovis-Gaffney for Zulu Alpha Firearms Channel. Be safe, be legal, and be responsible.